Integrity as a measure of a candidate's suitability to be chosen President of the Republic of Kenya is a matter the courts have yet to decide on. The supporters of presidential aspirants Uhuru Kenyatta and William Ruto, who have been adversely mentioned in the integrity case, were here to follow the proceedings that followed an earlier ruling that struck out the names of all the 5 presidential aspirants from the case. 2 of the petitioners, Njuguna and Omanga, through their lawyer Ambrose Weda, want the ruling overturned, arguing that the case would have no substance without the 5 being enjoined.
My clients were of the view that we needed to appeal so that the Court of Appeal could set aside that order that removed the 5 people so that the petition could proceed with the 5 of them. I then filed a notice of appeal and an application for stay of proceedings.
Meaning you may have to wait a little longer, about a month, to know the way forward on the integrity case. The 3 petitioners who filed the original case are Patrick Njuguna, Agostino Neto, who is now the MP for Ndhiwa, and Charles Omanga. Their lawyer was Anthony Oluoch. Later, Njuguna and Omanga sought the services of lawyer Ambrose Weda.
It was seeking the High Court's advisory opinion, jurisdiction, for the court to say whether or not people who are charged with crimes against humanity can run. And it was directed against the Attorney General as the respondent.
Along the way, the petition was amended to include Deputy Prime Minister Uhuru Kenyatta and Eldoret North MP William Ruto as second and third respondents because they were being adversely mentioned in relation to the Hague cases. However, on the 27th of September, the judges hearing the case, Justices Isaac Lenaola, Mohamed Wasame, and Philemona Mwilu, ruled that the names of all the 5 presidential aspirants, Kenyatta, Ruto, Odinga, Mudavadi, and Musyoka, be removed as respondents.
The first amendment is the one that brought in Honorable William Ruto and Honorable Uhuru Kenyatta. That has been struck out. The further amended petition brought in Honorable Raila Odinga, Honorable Musalia Mudavadi, and Honorable Kalonzo Musyoka. That has been struck out, leaving the Attorney General as the only respondent.
2 of the petitioners, Njuguna and Omanga, instructed their lawyer to appeal against the ruling that struck out the names of the 5 and applied to have the case stopped until that appeal is determined. Consequently, today, Justice Lenaola ruled that all the 5 presidential aspirants be served to appear on 23rd of next month for the hearing that will determine whether the case can continue pending the appeal or not.
The integrity case depends on the court process. It is not premised on the election date. A president can't be impeached because of those issues. So it is not something that you hurry over and step on people's rights because you are trying to beat certain deadline.
Both Uhuru and Ruto's lawyers are basing their arguments on the Bill of Rights, which they say gives any Kenyan the right to seek elective positions and that it is Kenyans themselves to decide who to lead them. Meanwhile, the High Court has thrown out a case by the International Center for Policy and Conflict seeking to compel the Independent Electoral and Boundaries Commission to reveal to the voter information regarding candidates for elective seats, for instance, whether they have criminal records or are tax compliant. Justice David Majanja threw out the case on the grounds that it was premature since IEBC was still formulating the relevant rules. The petitioner has, however, filed a notice to appeal against the ruling. Alex Chamwada for Citizen Weekend.